Our next case to come before the court is Wilmoth versus Akron Metropolitan Housing Authority. Good morning.
Good morning.
You each will have 15 minutes to present your arguments to the court, and the appellant may reserve up to 5 minutes. So when you're ready to proceed, we're ready to listen.
Thank you, Your Honor.
Just let me know if you want to reserve this.
I do, Your Honor. 5 minutes for the
That's fine.
appellant, Barbara
Thank you.
Wilmoth, actually the estate, now with Barbara Wilmoth. Barbara Wilmoth has passed away, as well as her flirting lawyer, Tom Henretta. So the last time we were here, I think we were talking about Judge Cassiopoulos' funeral. Today we're getting ready for
Can't take
Tom's.
one day for granted. It's a
No.
reminder.
Your Honors, we believe the trial court got it wrong down below. As I really looked at her order, I thought, well, I guess that is the starting point. That's the starting point for you. And she cites Title 5321.04a, and there are 3 subsections in there. And her discussion in her order is about the section on fit and habitable. And really the claim we're bringing is under 532104A3, which is to keep the common areas safe. There's no doubt in this case that this was a common area. While there can be some attempt to categorize this as a step or a curve, it is really a change in elevation in the back of the building. The Anadine building is a AMHA-run housing for the elderly disabled and the disabled, and Barbara at the time was both. This was the first day she had moved in, and she had been instructed to put her move-in boxes out on the back pad near the air conditioning unit, which is also the rear access to the building for the employees. They were to park down below in a lower lot, walk up a set of steps and into the back door. So this was a very familiar area to at least the employees and not to Barbara. So the question then is whether or not the condition was safe. And I would pose to you that the evidence in the case is pretty clear that the tenant, the landlord itself, believed that that change in elevation required markings. The original painting was white, and it was both on the horizontal edge of the highest part of this change in elevation and on the vertical riser. But it had deteriorated along with the concrete underneath it over time. And so Barbara, when she's in the process of making the maneuver to drop the boxes and go to her car, this change of elevation, according to our expert, along with the setting of the concrete that it was placed upon, made it very difficult for it to see, which I believe is what AMHA also had concluded.
My question is, from the pictures, it's a little hard to see. Was the cause of the fall that she just didn't see the difference in height, or did she step on a part of the concrete that was crumbled?
Well,
And if so, what caused the accident?
right. I believe this was a failure to observe the change in elevation. That's what I believe.
Okay.
Now, Barbara has been deposed, but of course I can't ask her that question at this point. And what I found to be, I believe, the error down below was first to say that somehow this landlord didn't have notice of a condition. If the trial judge meant to conclude that in her opinion that was not a defect, well, that's a different story, and that, I believe, still remains a question of fact for the jury. But if, in fact, presuming the evidence or construing it in our favor, that was a defect, that is, a change in elevation that's improperly marked, the warning has been allowed to deteriorate and degrade, such as to be ineffective, that, I believe, is an error on the part of the trial judge, that should have been construed in our favor. And the second part, which left me scratching my head, was that we presented no evidence that had the warning been there, Barbara would have seen it. And I tried to think of how we would have possibly presented that. And I imagine there would have been quite a protest from the other side if either Barbara or the expert had said, had it been painted either white or yellow, I would have seen it. I mean, I think at that stage of the proceeding, that bit of evidence should have been construed in our favor and left to the jury as to whether or not that warning would have been effective. Now, this is an interesting case because, as I understand the doctrine of open and obvious, it only operates when, to say that essentially the plaintiff is owed no duty. The condition is so patently obvious that the possessor of land had no obligation to do anything different than what they did, which was to maintain the hazard. But that's not the case here. This is a public housing landlord that had a duty to maintain the common areas in a safe and sanitary condition. We believe it wasn't safe. We believe they knew it wasn't safe. Otherwise, they wouldn't have marked it. They failed to maintain that.
When you say they marked it, how did they mark it?
They originally had painted it white.
Okay, I thought you meant they had put a cone or some sort of a warning.
No, it was a static warning, not an active where you go out and put a cone or a sign.
They recognized the condition existed that required a warning and put a red cone
Well, that's true.
on the sidewalk.
Yes, that's
But
correct.
that's not what you're talking about.
Not the case. And the interesting thing about this, and you can't really tell maybe from the photo we provided you, but it goes from being a very small change in elevation, an inch, up to 6.5 to 9 inches in different places around the curve. And it's only the portion that starts to become more than de minimis that they actually painted. There was some discussion in the depositions as to whether it had been repainted white at some time, but it was in the distant past. The guy who did the painting, who did the white painting originally, couldn't remember exactly, so we wouldn't hold him to it. But this is what we know. After Barbara was hurt in May of 2012, there was an incident report that has never been never produced. Now, had we been allowed to go to trial, we would have asked the court for a presumption that that non-produced document contained something, probably an adverse inference as to what they thought and when they thought it. You know, for example, I had asked that this be painted 5 years ago. This is why. You know, I don't know what might have been in there, but there was a testimony that the document existed, and then it somehow went missing. No one saw it thereafter.
But we don't know that it was specifically related to this area, do we?
Well, it was about Barbara's incident.
Oh, about her.
It was an incident report, Judge. And then what we do know is within 4 months, this curve is painted yellow, and they call it caution yellow. So I asked the director of operations at Joe DeFrancesco, you know, why is that done? And his testimony that was put in our brief at page 21 from his deposition says, you know, so that people can actually see it. It clearly is a difference. We're not saying that would be used for establishing they were negligent, but we are saying that it was evidence that this is not an observable or recognizable hazard to the average user when it was painted white, and certainly when it was painted yellow. But it was allowed to deteriorate, and I think we cited the case of Kerr in our brief. It talks exactly about that, a hotel allowing strips in the bathtub to deteriorate over time. So it's a recognition that some safety precaution, you know, design it out, guard against a judge, like you said, put something up to prevent people walking on it, or warn about it. They elected to paint it. They did not maintain that. And I believe that for purposes of a motion for summary judgment, we should have been permitted the inference that warnings are generally effective. Not always, obviously, but they are there for the purposes of alerting someone who is not familiar with the area as to the condition. that, I'll sit down, reserve my 5
Let me
minutes.
just make sure I asked you specifically this, I think you addressed it, but which code section are you alleging, specific code section or standard that's violated?
Yes, Your Honor, I think it's 5321.04A3. A3. Let me read it directly to you if I could. It says, so the general language is requires landlords, this is 5321.04A, requires landlords to comply with all relevant codes,
Right.
to do whatever is reasonably necessary to keep the premises in a fit condition, semicolon, and keep all common areas in a safe condition. A violation of any of these is negligence per se.
So you're saying that because of the failure to mark and the crumbling and so forth, that it's not maintained in a safe condition, you're not saying a specific code section per se was violated?
No, it's subpart 3, it says keep all common areas of premises in a safe and sanitary condition. That's what you mean. There's no building code that
That's what I'm saying,
that I'm
like,
aware of.
the height or anything.
Not that I'm aware of.
That's fine, I just wanted to double
Okay.
check. Thank you.
Thank you.
May it please the court, my name is Emily Yoder and I represent the defendant, App.No, Akron Metropolitan Housing Authority, or AMHA. As you've heard, the appellant in this case is critical of the change in elevation where this fall occurred and is critical of the fact that the paint on the curb had been allowed to fade and had not been repainted. These two facts are irrelevant to the trial court's determination down below. There's no evidence to suggest that it was the change in elevation that caused the plaintiff to fall. And regardless of whether this is negligence per se under the landlord-tenant statute or whether it's common law negligence, the plaintiff still has to prove causation. So the plaintiff has to establish or at least identify a question of fact that it's the change in the elevation that caused her to fall. There's no testimony and there's no evidence that this change in elevation in any way caused the fall. Rather, from the plaintiff's testimony, it is clear that the reason that she fell is because she threw her boxes, she turned, she stepped, and she never looked where she was going. This isn't a situation where the plaintiff testified that I looked, and when I looked, there was no change in elevation, and then I continued to walk, and there was this change in elevation that I was not aware of because of what I had seen first. That's not the testimony. Rather, the plaintiff's testimony is clear. She could not see anything because she was carrying these boxes. So the plaintiff didn't know that there was a change in elevation. She didn't know that there was a small change in elevation at one location and a greater change in elevation at a later location. The plaintiff's testimony is that she didn't see anything because she was carrying two boxes that were blocking her view. She turned.
I have, I guess, two questions in regard to that. One is, you said it wouldn't have changed the court's decision. Is that the basis of the court's decision, the causation?
My point is that the appellant is focusing on this change of elevation, but it's not relevant to the two claims that the plaintiff has established.
Okay, I apologize. I thought you were saying the court renders summary judgment on the basis of lack of causation.
I'm sorry.
And I was like, I'm not reading it that way, so I didn't understand where you were coming from. I apologize.
No, well, I probably misspoke.
No, okay. I misheard you misspoke, so where to go?
No, the point is simply, yes, there is a change of elevation. That's not why she fell. She wasn't relying on something that she had observed where there was a slight change in elevation and then later that was different and she wasn't expecting it. Her testimony was she could not see because she was carrying the boxes. She discarded the boxes, she turned, she's in an unfamiliar setting, but instead of taking a look at what's around her, she walks and she falls.
How long had she been in the premises?
She had moved in the day before, so she had, it was her testimony that she had never been in this area
Been out
before.
that area.
That was
And she was told to take the boxes out there.
correct, that's where the boxes should be discarded.
And I understand your argument, but of course another argument could be made that your client is aware that these are disabled elderly people that have lack of mobility, maybe have vision problems, all kinds of things that you're going to be facing then in that building. And so you tell them to take these boxes, so it sounds like a recipe. I should tell your kids, this sounds like a recipe for disaster. You tell them to take your boxes, carry them out there, and discard them, and make sure, you don't warn them, of course, but they better be making sure, because it's crumbling concrete and it slopes down and has different heights in the area where you have to dispose of your trash. So I understand your point, but on the other hand, the counterpoint would be that, like I said, is a recipe for disaster based on the population, especially that you're serving there.
Potentially, but there's no testimony in here from Ms. Wilmoth that she couldn't see, that she had difficulty getting around. I mean, rather, I think the testimony was she was doing well before this, and then because of the fall, she had certain limitations. But, so perhaps, you know.
Well, she wouldn't have qualified there unless she had some problems, right?
And I believe that age may have been a qualification as well, but I'm not certain on that. I do believe it's in the record.
Not what, just so you know. Just saying.
Thank you.
170.
That's right.
Well, I'm not far from any of those, so.
Go ahead, I'm not making any representation on what is old.
I want to make sure I'm politically correct here, okay?
No, but the point, there's no testimony that that's why she fell. And honestly, I mean, if you look at the pictures, where she fell is a standard curve. I mean, it's not that the slope is the sloping area where she fell. I mean, she stepped off of the curve. So essentially, to say when you're serving a population that is, you know, older or has certain disabilities, then the standard that you have to adhere to is you don't have curbs on the property. I mean, that's an unworkable, in my opinion, an unworkable standard, is to say if this is your population that you're serving, you can't have curbs. The other issue that the appellant has raised is that the issue with respect to the paint. Again, this is irrelevant to the determination of whether summary judgment was appropriate, because as we've heard, Ms. Wilmoth did not look. She turned, she stepped, and she fell. And as Attorney Scanlon suggested, that there, you know, we've argued that there's no evidence that had there been a warning, she would have seen it. But certainly, Ms. Wilmoth could have testified, I looked and I couldn't, you know, because the paint had worn, or because it wasn't marked appropriately, I thought it was all the same level. But there's no testimony to that.
Now, her testimony is, I was carrying boxes, and that's why I didn't see it.
Well, her testimony is I was carrying boxes, which is why I didn't see anything originally. I didn't observe my surroundings. I turned, I tossed the boxes. I turned again, I didn't look, I stepped, and I fell.
So she conceded she didn't look down.
Correct. Yeah, her testimony is I tossed the boxes, I stepped, and I fell.
So she walked toward, when she had the boxes, and she was walking towards dumping those where it was low. She dumps the boxes, turns around, and walked off in a different direction.
Correct. But again, there's no testimony that, I mean, her testimony is she didn't see anything, she didn't observe anything about the surroundings. So, you know, it's not that I saw it and it was low. It was I couldn't see anything because of these attendant circumstances. And with respect to the attendant circumstances, it's our position that, you know, trash in an area where someone is directed to dump their trash is not an attendant circumstance. That's something that you would expect to see in an area where trash is being collected. There's some suggestion that there was construction going on. However, the testimony is actually that there were some sawhorses present. And the fact that plaintiff was carrying the boxes that obstructed her view and was unfamiliar with this area should have led her to take greater caution about what was going on around her instead of, you know, less caution.
Where were the sawhorses?
I'm not sure. I don't think that that's actually depicted in the.
I don't recall seeing them in the picture.
They're not. There's just a reference.
So how are they relevant?
It's the appellant's position that that was an attendant circumstance that would negate the opening, or that would be taken into consideration when determining whether this was open and obvious.
So when you filed your summary judgment motion, you alleged, and I mean you, your client, the allegation was that AMHA was not responsible because the plaintiff did not prove causation.
When we filed our motion for summary judgment, I believe that the arguments were that the plaintiff had cited the landlord-tenant statute, but there were no questions of fact as to any of those. And when we filed our motion for summary judgment, it was unclear, as you were questioning, exactly which provision the plaintiff was relying on. In response, the plaintiff submitted an expert report, seemingly arguing that subsection 1 was satisfied, or A. We responded that the expert report was insufficient. The issue of whether it was safe, I don't believe was really ever raised expressly.
The issue of whether it was safe?
Yeah, under subsection 3, was not really an issue that was argued to the trial court. But our position was that, yes, that there were no questions of fact that would allow either of these claims.
But my specific question to you is, and I hate to put you on the spot, but I have to, and we'll be reviewing the record anyway. Did AMHA specifically allege that she could not demonstrate proximate cause of her injury? And if you don't know, that's fine. It's just that seems to be the thrust of your argument here this morning, and it didn't seem to be the thrust of the brief.
No, I don't think that, I agree with you that it wasn't the thrust of the brief, but I think in preparing for this, there's a lot of distraction over, the slope and the paint, and, as I was preparing, I think that what we argued in the trial court was sufficient. I think that the trial court, that the decision is correct and it should be upheld. But I think that as this has progressed, that there's been a confusion and sort of a distraction of the issues into the slope and the paint.
And I have that happen all the time when I'm a practicing attorney. It drives me crazy because we all go off on a tangent and then we're like, what are we even talking about anymore? But the problem with that is you move for summary judgment. AMHA did. So what we can only look at and what the trial court could only look at was what AMHA, because it's initially your burden, and they only have to really respond to what the burden is. And so that's why I was asking you specifically that question.
Sure. And I'm not sure how well that was briefed down below. I do believe that the issues that were raised down below were appropriate, the arguments that we made were appropriate to show that there are no questions of fact. That the problem here is that the plaintiff was not looking where she was going, and that's why she fell. It's not because of anything AMHA did or failed to do. There's no suggestion that had there been paint that she would have seen it. She wouldn't have, because we know from her testimony she didn't look. So essentially, the appellant is critical of the area where the fall occurred, but the fact is the plaintiff didn't look where she was going, and AMHA satisfied all of its burdens that it owed to the plaintiff under the landlord-tenant statute and under principles of common law negligence. And so we would ask that you affirm the trial court. If there are no further questions, that concludes my argument.
I don't believe so. Thank you.
Thank you.
You have your 5 minutes.
Thank you. As I understand the argument today, this is an open and obvious defect that she failed to perceive, and that caused her injury. But that's not the law. That only operates where there's not a statutory requirement. I would say, Your Honor, Judge Card, you did get it right. The judge's decision was based basically on the law and not on a question of fact. The only reference to the facts is the opening paragraphs that say at the point the plaintiff turned, stepped off the curb, fell onto the ground, and sustained certain injuries as a result of the fall. She took that as a given. The question really is, who had the duty to make sure that the place was safe? And it certainly wasn't the tenant, it was the landlord. The judge concludes, she mentions, she says, Stark's opinion might be construed to raise an issue as to whether the defendant satisfied its duty to keep the common areas of the premises in safe condition. However, the plaintiff has pointed to no evidence that the defendant was aware or should have been aware of a defect or a hazard existed such that it would render the property unfit, unsafe, or uninhabitable. Oh, that's the point. They painted this white for a reason, because of its unusual change in elevation. They failed to maintain it, and after she fell, they painted it caution no. So that the court is right there at the point, using an analysis on the issue of notice. They created it, they maintained it, and they failed to maintain it, and that is the claim against them. Secondly, she goes on to say, accepting as true the plaintiff's assertion that the white paint on the curb was faded and not sufficiently visible to serve as a warning, plaintiff has not pointed to any evidence that defendant had any notice or knowledge of the condition. Well, it's on their property. They walked over it. They painted it white, they failed to maintain it, and they ultimately painted it yellow. And why? And I believe that why is in the missing document that they've never produced. Now, the judge then concludes that we presented no evidence sufficient to raise as to whether any defect in the walkway or curb or the property violates 5321.04A, 1, 2, or 3. That was the decision of the trial court. We believe we presented more than sufficient evidence, especially when you construe this in our favor, to essentially argue down below and up here a collateral attack on that statutory duty by arguing open and obvious. Then we will eliminate the need for any landlord, and especially at public housing. And I would say that this is not for the elderly. This place was for the elderly disabled and the disabled. So I believe they had a higher duty. That's my argument. Under the DiGiraldo case, I think, in 1969. When you're dealing with the infirm, the elderly, and children, we have the highest standard of care, of ordinary care, whatever that may mean.
When you use the word disabled,
Yes.
is that broadly, whether it's mental or physical, or if it's physical, does it mean someone who is not independent and otherwise requires extra services to be safe and whether they're inside or outside?
That's a good question, Your Honor. I don't believe this has any assisted living feature to it.
Okay.
But Barbara was an RN by training, and she was disabled due to she had a cardiac condition.
All right.
She had
Thank
some
you. That
others.
clarifies the
And
circumstances.
are there any other questions?
I don't believe so.
We urge the court to reverse and remand. Thank you.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a written opinion, and we will release our cases on the website and have it sent to you.